Fantastic. Okay, hi everyone. Welcome to this panel of the Canadian Association of Food Law and Policy Conference. This one, we're so excited to have speakers who will be presenting on the topic of migrant work and agricultural food production. And how this panel will work is we have a series of speakers who will each present for 10 to 15 minutes. And then at the end, we'll have some time for questions. And I would encourage you that if you have any questions that, we'll have the Q&A period, and then you just raise your hand using the reaction function on Zoom. And then, I'll step in and you'll be welcome to ask your question directly to any of the speakers. Alternatively, if you prefer, you can type your question in the chat, and I'm happy to read them out. But it'd be nice to also just have people engage in a conversation here. Okay, so without any further ado, I will turn it over to Chris to introduce himself and the rest of the speakers.
All right, I just unmuted myself. How y'all doing? What's up? I'm Chris Ramsrup. I'm an organizer with Justice for Migrant Workers. And I always have to highlight that I am the non-lawyer here, okay? Everybody else seems to be lawyers on this panel, but that is not moi. But however, I'm privileged and honored to work with all these people. The context and the framework that I usually try to position this work around is identifying Canada's temporary foreign worker program, and particularly the seasoned agricultural worker program as a form of apartheid. And what each of my comrades, they're not just friends, they're not just colleagues, they're not people I work with, they're comrades. We struggle together to try to inform our analysis, our organizing, and to reflect on the good and the bad when it comes to what we see pretty much on a daily basis with the workers in Canada. So each of my comrades will be speaking from a particular vantage point of their work, particularly during the pandemic, but what their experiences have been, their observations, their reflections, analysis in the work that they've been engaged in. So my comrade Shane Martinez, who will be up after me, will be speaking about his reflections around human rights organizing and the use of human rights codes and migrant farm workers, and some of the work that we've done around racial profiling, for instance. Dr. Vasanthi Venkatesh, who's at Windsor Law and the faculty there, will be speaking about immigration and immigration forms of exclusion. Ilya Demetsky, a lawyer out of the Chatham-Kent area and the Windsor-Essex area, will be speaking about the role of organizing and looking at occupational health and safety and employment standards. Comrade Sarah Khan, recently called to the bar, will be looking at housing and the ways that migrant agricultural workers are excluded. And we will also have Tanita Doma, who unfortunately has to work with me on a quite regular basis. And she's going to talk about her work and her experiences around the vulnerable work permit and why, straight up, that system is whack. Now, if you're offended by harsh language, the use of white supremacy, racism, this may not be the conversation for you. So you can gently peace out at any moment right now. So the three concepts to introduce, and I promise not to yap. Most of you already heard me yap enough times and worried to death. But I want us to understand why we say apartheid. And it comes from this idea of agricultural exceptionalism, that we've created a set of laws by the state that treats the entire agricultural industry, but particularly its labor, very differently from other aspects. And this is with respect to immigration, with respect to housing, with respect to employment standards, and rooted in the idea of agricultural exceptionalism is unfree labor. And the racialized component, of course, undertakes with the fact that the farm workers, and particularly workers under the seasoned agricultural worker program, are all racialized workers from the global south, particularly the Caribbean and Mexico. So we have to situate the existence of this program as a legacy of colonialism, as a legacy of indentured labor, which brought my people over, the Bracero program, which has been involved and operating in the United States for generations in one form or the other, and of course, rooted in slavery. So the legal exceptionalism that exists is a result of emergence of a system of unfree labor that accentuates the power imbalances that disenfranchise farm workers through multiple ways. Migrant farm workers, of course, cannot vote. They cannot engage in politically, socially, or economically, which means when local cities engage in bylaws, it's very paternalistic and racist because the workers' voices are not included. The exclusions of agricultural workers from multiple forms of Ministry of Ontario labor laws, for instance, coupled with the tied work permit, deny workers, number one, the ability to exert their rights. And number two, if they do try to exert their rights, well, they're not going to get overtime pay. They can't form a union. And also it takes on another dimension when we're looking at a racialized community. And other people who are more smarter than me will tell you about what that actually means. While the federal government and many other organizations have been championing the idea of regularization, our demand around regularization is a bit more different that we have to, first of all, identify. So it should be everybody here should know that our current conversations of regularization, or status upon arrival, excludes migrant farm workers. So despite the 50 years, there's never been a program of access to residency for farm workers. So we have to question, why is that? Why do we continue a system that excludes workers? Even if a system that was set up through pilot projects, such as the AgriFloom pilot project, I'm sure Professor Venkatesh will talk more about it, the racially coded ways, and going back to, of course, the idea of apartheid, of how agricultural workers will be excluded for literacy requirements, language requirements, and other forms of ways that will deny agricultural workers any form of pathways to permanent residency. The other critique about pathways to permanent residency is that employers should have no say whatsoever in the sponsorship of workers. That's going to simply perpetuate a system of docility where workers will choose rather to be silent and not exert their right around dangerous working conditions so they could have the ability to live here as residents. So employers should not have any control or any say in who is able to stay here. The last component around regularization that I hope we could interrogate and talk more about, and you could throw stuff at the screen, especially bad tomatoes, is for us to start thinking beyond the idea of regularization for the right to move, the right to stay, and to start considering the rights of people should be portable. So whether it's employment insurance, healthcare, workers' compensation, or the right to move, these should be portable rights where people should have the ability to move between their home country and Canada freely without imposition or obstacles from the state or employers. Now, so basically what I am saying is about dismantling the current state, but not dismantling workers' ability to come to Canada. Let me be straight up what I mean by that. We're not here to say that workers should not be able to work. We have to value the skills that they provided for our society for generations, but they should not be chained or shackled to an employer. People should have the ability to move to freely and to participate in the society so they can improve their standards for themselves and others. Now, there's been many calls around sectoral permits, and we strongly oppose those as well too. It's not about simply having people to circulate on an exploitive labor market, but about having people the ability to move freely and not be just basically tied to an industry which is exploitative as a result of this legal exceptionalism that exists. I think my final comments for now, and then I promise I will be talking more at you, promise. When I see one of my students is here, so shout out, I'm not gonna embarrass you, but thank you for coming to my peeps. It's for us as activists, as organizers, and as policymakers. And this is straight up. We have to ensure that we are not trying to get credibility in the eyes of the state. This is not about throwing all our eggs in our basket and saying, please, massa, accept our demands, but it's about building our community and making sure that our struggle is rooted in resistance, where we listen to workers and we develop policies with workers and with the community to build and empower, not just simply going to the government and trying to beg for crumbs, because that shows how it hasn't worked in the last 55 years. So it's about dismantling the system of apartheid. It's about ending the racial subjugation of Black and brown workers. It's about ensuring workers have the right to bargain collectively and to improve their workplace, to engage in all forms of democratic participation, civically in the community, electorally, and in their workplace. And it's ensuring that we've learned from history that when my family came to the Caribbean as indentured laborers over 100 years ago, that my family that continues to work in these programs today should not be working and living under the same conditions today. So learning the mistakes of the past to create a society where our food system is not based on extractive practices and policies. It's not about basically suppressing people's rights the world over. So examining our footprint, examining the implications of our policies on the workers here, and trying to create a society which is much more different from what we have today. So I'll leave it from there. I believe I'm tagging in Shane. Shane, it's yours.
Wonderful. Thanks a lot for that, Chris. And yeah, good afternoon, everyone. Thanks for having us. I guess, it's perhaps uncontroversial to observe that much of our so-called local food is grown and harvested by people who have come here from abroad, as Chris mentioned. This includes people who have come here through both authorized government programs as well as people who have come here through other ways. Now, insofar as undocumented workers are concerned, who are often indentured, as Chris mentioned, it's not uncommon for us to hear this term human trafficking. We oftentimes hear it when CBSA raids farms or greenhouses, going after undocumented workers who are there. To begin, I want you to try and put aside for a moment any existing notions that you have about this term human trafficking. Although it's something that features prominently and repeatedly in modern Canadian media, it's a term which, unless it's properly understood in a broader context of historical colonialism and ongoing food imperialism, it can risk misleading us about the circumstances of foreign laborers in Canada. And I'm going to be looking at how migrant farm workers are subjected to differential treatment by the Canadian government, police, and immigration authorities in their selective efforts to purportedly address human trafficking. Now, since 1966, the Seasonal Agricultural Worker Program, also known as the SOP, has been administered by the Canadian government to provide farms, greenhouses, and similar operations with tens of thousands of laborers recruited from Mexico, Jamaica, and the Eastern Caribbean. Now, over the last 20 years, courts and tribunals have paid increasing attention to the plight of migrant farm workers. The Human Rights Tribunal of Ontario most recently found in Logan versus Ontario that the SOP is rooted in structural racism, both historically and in the present day, and creates vulnerabilities that impact migrant farm workers' ability to assert their rights. Now, during this same period that these decisions have been emerging, we've also seen the development of an extensive legal framework aimed purportedly at human trafficking. The first offenses directly addressing it were added to the criminal code in 2005, including trafficking in persons, receiving a material benefit from trafficking, and withholding or destroying documents to facilitate trafficking in persons. Canada has trumpeted the value of these efforts, in particular as they relate to combating human trafficking in the sex trade. However, an internal contradiction arises when Canada's anti-trafficking laws are juxtaposed with the systemic oppression and exploitation that has historically characterized the SOP. Participants in the SOP contend with conditions which in many ways mirror those experienced by undocumented workers who have been trafficked. This requires, I think, a closer examination of how Canada determines which human trafficking activity is criminalized and which is not. And that's really a determination that turns on how the government, how the state has redefined this concept of exploitation within the criminal code. And such an examination, it really allows us to ascertain the political and economic purposes served by this redefinition and how it impacts anti-trafficking efforts on the ground, and really helps us better understand the similarities that actually exist between what the government does and what it purports to be fighting. So section 279.01 of the Criminal Code reads as follows. It says, every person who recruits, transports, receives, holds, conceals, or harbors a person or exercises controlled direction or influence over the movements of a person for the purpose of exploiting them or facilitating their exploitation is guilty of an indictable offense. For the purpose of analyzing how this section does or does not relate to SOP participants, we can distill it down to the two principal parts of any criminal offense. As for the first part of the analysis, the criminal act, it is quite clear that employers in the agriculture industry, in consultation with Employment and Social Development Canada, routinely recruit people from abroad to work in Canada under the SOP. This requires us to ask what is causing people to come here in the first place. And the answer almost always is economic destitution that's resulted from Western influence, exploitation, and oftentimes, as I noted earlier, policies of food imperialism. These employers then engage the services of third parties to transport workers to Canada. Employers or their representatives then receive the workers at the airport and transport them again directly to rural farms where they'll work and reside during their time in Canada. Once SOP participants are in Canada, their employers exercise significant influence over their movements. Nearly all SOP workers are contractually directed to live in bunkhouses or similar dwellings on isolated farms where they work. They lack labor mobility as a result of being contractually tied to a single employer in Canada. Most workers rely on employers to provide them with transportation to nearby towns for the purpose of buying food, sending money to loved ones back home, and so on. These workers are constantly aware that their movements are supervised and monitored by their employer, and engagement with Canadian society must not be such that it upsets their employers. Employers are able to exercise complete control over their workers' movements and every other facet of their lives here in Canada, especially through conditions in the contract which require the workers to immediately return to their home countries if their contracts are terminated. The second part of the analysis, focused on the criminal intent or purpose behind this offense, raises the question of whether all of this is done for the purpose of exploiting or facilitating the exploitation of migrant farm workers. So let's look at some definitions of what exploitation is. The Oxford Language Dictionary defines exploitation as the action or fact of treating someone unfairly in order to benefit from their work. Black's Law Dictionary defines exploitation as the act of taking advantage of something, especially the act of taking unjust advantage of another for one's own benefit. Now, these dictionary meanings of exploitation appear synonymous with what we would consider to be the ordinary or literal definitions of the word. However, Section 27904 of the Criminal Code defines exploitation differently. And effectively, what it does is that it makes a finding of exploitation contingent on the contextual presence of factors such as threats, fear, or coercion. Effectively, what you have to do is you have to cause the person who's providing the work to believe that their safety or the safety of a person known to them would be threatened if they failed to provide their labor. The criminal definition of exploitation is thereby limited to circumstances where typically non-state and non-corporate actors utilize intimidation tactics to secure the labor of another, while alternate, but not necessarily less oppressive modes of exploitation are permitted to be used by the state and by its corporate partners in the farming industry. A textual analysis reveals that this is very much the intended product of careful drafting by lawmakers. So how do we get here? So before exploring, I guess, how such a limited definition of exploitation benefits the state and employers of migrant farm workers alike, it's important to dispel any notion that this arrangement is the product of legislative inadvertence. So we can look at legal scholar Ruth Sullivan, who has said, legislatures say what they mean and they mean what they say. They do not make mistakes. And when the human trafficking provisions of the Criminal Code were drafted, the existence of programs such as the SOP required lawmakers to reconceptualize what is meant by the word exploitation. And this is due to the fact that exploitation, as it's plainly understood, is reflected in every aspect of the SOP and is at the core of the relationships between migrant farm workers, their employers, and the Canadian government. How does that exist? How are they similar? Well, employers recruit, transport, receive, and control migrant farm workers and their movements for a basic purpose: to generate profit by extracting the maximum amount of labor from them at a minimal cost. And this is accomplished in part by employers taking advantage of pre-existing economic desperation that compels individuals overseas to seek work on Canadian farms. Political scientist and professor Dr. Michael Parenti has repeatedly described the opportunity that economic disparity abroad presents for capitalism here at home, noting that the poorer you are, the harder you will work for less. And Canadian farm owners make the most of this situation by having migrant farm workers endure conditions that most Canadians are not desperate enough to accept. This includes working 6 days a week for between 60 to 70 hours, making minimum wage regardless of one's years of service. Employers also save money by providing workers with substandard accommodations, typically in overcrowded bunkhouses, which in Ontario are exempt from the protections provided by the Residential Tenancies Act. Migrant farm workers are often provided with inadequate training and personal protective equipment, and it's not uncommon for some employers to expeditiously repatriate workers who fall sick or injured on the job, thereby avoiding potential costs associated with workers' compensation claims. The Canadian government, as the architect and overseer of the SOP, facilitates this exploitative arrangement. The government, in collaboration with representatives from the Canadian agriculture industry, negotiates contracts with the governments of Mexico, Jamaica, and the Eastern Caribbean countries. Workers have no say whatsoever in the contract negotiations. And in Ontario, workers are in fact prohibited from unionizing. The government also benefits from arrangements such as the EI system, where migrant farm workers are required to contribute to EI, but they can never collect regular benefits. Now, all of this takes place in the context of the federal government taking advantage of SOP participants' economic desperation, knowing that they will come to Canada even if they are denied the opportunity to have their families join them. They're also treated as being permanently temporary, a phrase which I believe was coined by Dr. Jenna Hennebree, as they're denied any opportunity to obtain permanent residence in Canada. So when we look at this and we look at the history of the SOP, it continues to operate very much today as it did when it was founded over 50 years ago. And when the SOP is examined in its totality, the historical and continued racialized exploitation of these most vulnerable workers is at a level entirely at odds with any concept of fairness, respect, or equity in employment. And but for the novel redefinition of exploitation, which we reviewed, their treatment would arguably be at odds with Canada's own anti-trafficking legislation. The same interests as well, which prompted Canada's redefinition of exploitation in relation to human trafficking, also inform its broader approach to enforcing the law. And we see that in that the trafficking of foreign nationals working in areas other than the sex trade is more a focus of the Canada Border Service Agency, CBSA, than it is for police. And Section 118 of the Immigration and Refugee Protection Act, also known as IRPA, much like Section 279.01 of the Criminal Code, explicitly prohibits knowingly organizing the coming into Canada of one or more persons by means of abduction, fraud, deception, or use or threat of coercion. Now, despite this comparatively broader language under the IRPA, which allows for the CBSA to go after recruiters who employ fraud and deception, the trafficked workers themselves are often the ones criminalized. And by trafficked, I'm talking about people who are brought here or facilitated to be brought here, but may not meet the strict definition under the criminal code. It's commonplace for undocumented migrant farm workers who have been lured to Canada under false pretenses to not be treated as victims, but instead be detained due to other IRPA violations, such as working without a permit. They themselves are effectively criminalized. They are sometimes held in jails instead of in immigration detention centers pending removal, with their deportation all but guaranteeing that they'll be denied any remedy for abuse or other maltreatment that they may have experienced in Canada. Now, CBSA is provided with billions of dollars by the state and is responsible for surveillance and deportation measures targeted at migrant communities across the country. Yet we see no comparable investment from the state to keep migrant workers safe from, for example, COVID, which led to hundreds of infections over the pandemic in overcrowded bunkhouses and even led to deaths. While enforcement action outside of the sex trade occasionally has led to the rescue of indentured laborers, it has done nothing to address the root causes of exploitation. And in fact, to the contrary, the structure of the SOP and CBSA's purported preservation of the integrity of the legal farm work program is, in large part, about preserving market control and dominance. The systemic treatment of precariously situated SOP participants reveals that their health and safety and general well-being is at best, it's a secondary concern to the Canadian state. Enforcement action within the agriculture industry at its core is preoccupied with ensuring that the government and its corporate partners maintain order and exclusive benefit from foreign labor that is used to generate billions of dollars in revenue every year. And one commonality between the human trafficking of sex workers and migrant farm workers is how racialization has impacted their interactions with law enforcement agencies and the courts. And I'll just mention this point before wrapping up. So anti-trafficking efforts by the police have prioritized enforcement around the sex trade, but research has shown that there's actually a lack of support for racialized complainants involved in trafficking investigations. Now, findings by Dr. Katrin Roots suggest that a cause of this is, quote, class, race, gender biases underlying the anti-trafficking efforts. And Dr. Roots goes on to say that the expression of these biases among lawyers and the police are said to contribute to the shaping of a trafficking matrix in which race and poverty are effectively criminalized, as anti-trafficking efforts are not applied equally, but instead target certain segments of the population with historically varied effects. And in this way, we see that migrant farm workers are not alone in how they're adversely impacted by these so-called anti-trafficking efforts, and that their treatment is part of a larger systemic devaluation of the racialized poor by the Canadian state. Now, addressing human trafficking at its root level requires us to delve into questions of causation, which prompts individuals, what's prompting individuals to take risks inherent to laboring as migrant farm workers. We also have to examine the motives of those entities eager to take advantage of impoverished workers by bringing them to Canada, whether legally or not. And an honest approach to these questions requires us to first acknowledge that legal frameworks for exploitation, such as the SOP, can and do operate in ways and for purposes substantially similar to those who illegally operate in competition. And the state and the agriculture industry, like those who traffic in undocumented workers, identify a need within the Canadian labor market. All three target and recruit the most vulnerable workers available, workers who are almost invariably racialized, impoverished, and from the global south. They then proceed to transport them to Canada and have them labor in conditions that Canadian workers have rejected, and reinforce barriers which prevent workers from exercising their rights under the law. All three of them isolate workers in a way that effectively keeps them invisible in a state of constant precarity, where it's ensured that they're denied a voice or participation in civil society. And at all times, the agriculture industry and illegal traffickers are motivated by the same overriding motivation, which is, again, the accumulation of profit. So to close off, I would just say a radical paradigm shift that recognizes the human dignity of migrant farm workers is possible. We can redefine our approach to foreign policy into having people come here. As Chris correctly noted, it's not about saying workers from other countries shouldn't be coming here and laboring alongside of us. Absolutely not. It's not about that. It's about making sure that the conditions that they have when they are here are just equitable, fair, in which they have a say. And when we look about what's happening around us right now with the labor movement and what's underway in Ontario, we need the labor movement. We need lawyer allies and progressives from all circles to tap into the energy that we see in Ontario right now and use that same momentum to stand in solidarity with migrant farm workers and ensure that conditions in which our food is grown reflects values, again, of justice, equity, and empowerment of workers. So thank you very much.
Okay, thank you, Shane. Next up is Dr. Vasanthi Venkatesh. Vasanthi, the floor is yours.
All right, let me unmute myself. Thanks so much, Shane. So I will continue with what Shane said, but how Chris introduced this panel in talking about the roots of the agricultural system that we have in Canada and the role of immigration. So Canada's Migrant Farm Worker Program, a linchpin of food production in Canada, was conceived to sustain a settler colonial agricultural sector. And second, it uses Global South labor in a dynamic which Dr. Adrian Smith has called mobilize to immobilize, which he derived from the study of plantation labor. So how does it work? This global South labor is used to offset the comparative disadvantage of the Canadian food sector in the global political economy because of seasonal weather, production costs, and smaller markets. So racialized and class oppressed workers from the global South are displaced, often internally displaced first, and economically oppressed first historically by colonialism and now by current racial capitalist neoliberal political economy. So these workers are mobilized under a narrative of supposedly consensual freedom, the SOP work permit and other forms of work permit, to engage in wage labor that deliberately immobilizes them within Canada using the tied work permit-based immigration system. So workers come year after year to work on Canadian farms, spending most of their lives away from their families without any prospect of permanent settlement. The link between immigration and food in Canada is as old as colonialism. The agricultural temporary foreign worker programs are rooted in the formation of the Canadian settler colonial state through the displacement and the replacement of Indigenous peoples and the pursuit of taming the land, so to speak. Agricultural cultivation was one of the primary ways to induce immigration of desirable populations who could cultivate the land in this Lockean, Eurocentric Lockean ideal to occupy the territory of Indigenous nations. The first Department of Immigration was in fact formed under the auspices of the Department of Agriculture. And then both together, Department of Immigration and Department of Agriculture, together was later called the Department of Immigration and Colonization. So since the beginning of the colonial project, finding a seasonal workforce for agricultural labor was a challenge. Various incentives were provided, such as free passage for British citizens with a subsidized return fare, and temporary labor importation schemes were set up for Eastern European citizens. While some settled, many, especially Irish and Eastern Europeans, went down south to the United States. So then fast forward onto the 1960s, until 1962, immigration and the right to citizenship was based on racial selection. But simultaneously, the state was also creating a population of socially and politically disenfranchised, exploitable and expropriatable labor force of racialized people. In the late 60s, finally, there was a shift from a racial white-only immigration selection to a facially neutral points-based skilled immigration program. On the face of it, this program seems neutral because it's based on numbers, but it instituted a differentially racialized system to cater to a racial capitalist agricultural economy. And then, as we all know, in response to an agricultural lobby which cried that the points-based system is not going to produce labor for their workforce, Canada launched a seasonal agricultural work program with 264 workers from Jamaica. And since inception, this program, the SOP program, assigned foreign workers a permanently temporary status with no access to permanent residence. This feature continues essentially unchanged to this day, only having expanded the number of source countries within the SOP program to all of the Caribbean countries and Mexico. And then the 2-year program got instituted when they could now be all around agriculture production using greenhouses. But this residency restriction was not a matter of chance. It was specifically instituted to ensure a constant supply of precarious labor responsive to fluctuating economic and climatic conditions. Mexican workers now form the largest group of workers under the SOP program, and Central American workers in general form the larger group, including the 2-year program, which talks about a displacement of Caribbean Black workers who were deemed to be troublemakers at some point or the other in this narrative of displacement. So employment can be discontinued at the will of employers, and the workers returned if the harvest season has been slow or if they're injured for any other reason. And this process is euphemistically called repatriation, to differentiate it from state-controlled deportation, which at least provides for a hearing and judicial review. So the agricultural food production in Canada is full of euphemistic narratives which are so deeply racist that it's kind of astonishing that does not form the focus of this entire conference that we have over here. So another euphemism is naming. Farm employers name the workers they want to re-employ for the subsequent years, but often based on racial stereotypes and the forced docility of workers. More than 80% of workers are named year after year. This threat of repatriation and future employment creates a regime of self-disciplining and fear and a constant awareness of the uncertainty of their presence in Canada. And employers have full control of the working conditions and the possibilities of future employment of migrant workers. So in addition to employment immobility, we'll hear from Sarah and others, the workers' physical mobility is restricted due to structural dependence on their employers for housing, transportation, and everyday living. Social relations are further controlled by limitations on their place of residence and by preventing the families of foreign workers from joining them. Their legally anointed free and temporary status therefore ensures a disciplining and an immobility that has consequences for building power and solidarity and also for making legal claims. So let's dig more into this. Is it really a question of chance, or is this actually a deliberate strategy by the Canadian state and by the food lobby? So agriculturalists form a strong lobby group advocating for the corporatized industries to be subsidized to cheap unfree labor, legal exceptions, and also state funds. Government expenditure in agriculture was $5.4 billion in 2016 to 2017 and was estimated to be 26% of Canada's GDP. And these numbers haven't changed much. Yet, the economic and social power of the agriculture sector revolves around this discourse of the yeoman farmer producing essential food security to Canadians. But is it really? Who are these yeoman farmers? Over the past 50 years, the number of farms in Canada has decreased by half. The average farm size has doubled and farm value per acre has almost quadrupled, with a small number of large farms earning the majority of revenues. 70% of migrant farm workers are employed in large farms, which earn more than $2 million in revenue per year and largely from exports. Realized net income in agriculture during the pandemic year, in fact, rose by 84.4% to $9.4 billion in 2020 during the pandemic. The job vacancy in the agriculture, as defined to earn a specific amount of profit, is deemed to be higher than any other sector, putatively resulting in 1.5 billion lost sales annually. The SAW program, you can see now why is considered the linchpin of the horticulture industry, essential to maintain the economic output of the industry. Even during the pandemic, the number of agriculture farm workers did not reduce, and in fact has only been increasing since 2020. So you can see the yeoman farmer discourse was especially evident during the pandemic. There was swift closure of all but essential work in Canada when the pandemic was declared, but farm workers began to be deemed as essential work, and the border was open to migrant farm workers from the Caribbean and Mexico who would arrive by chartered flights. You know, we all know within a few weeks what happened, death of workers, massive outbreaks in farms, and along with long-term care homes, agriculture farms with migrant farm workers became the center of the largest infection outbreaks. And along with this, while the agriculture sector came under public scrutiny, it was accompanied by a discourse pathologizing these workers as disease carriers, causing the proliferation of the virus from racialized foreigners to white rural communities. And workers faced increased xenophobia and so on. The construction of migrant farm workers as dangerous and deviant is an essential ideological component of the system of labor and freedom. It has been used to normalize racist discourse in zoning laws, loitering laws, housing laws, racial profiling by the police, starkly seen in the DNA sweep of over 100 Caribbean migrant workers that Shane represented in a recent successful HRTO decision. But racialized hierarchies that were overtly defined in law before in immigration law historically continue to perpetuate and be reified in colorblind laws. Ironically, a large percentage of this food is actually exported. Schuyler Farms, which led the appeal that limited the number of workers for bunkhouse, limited the number of workers who could live in a bunkhouse, proffered a lot of evidence at the appeal board to show how the workers enjoyed being in the farm. That is, bunkhouse, in fact, are like summer cottages, and it is the workers who want to live in close proximity, and they do not want restrictions on bunkhouse numbers. The same farm exports more than 70% of its produce. Yet, the farm owners spun the rhetoric of how all this was done for Canadian food security. This racialized exploitation continues in many insidious ways. Employers reify cultural stereotypes to prefer workers from one country over the other. And this is defined in critical race scholarship as differential racialization. For example, Jamaican workers are considered to be more confrontational and demanding, but they're suited to orchard work, that is reaching upwards, and tobacco, which is heavy loads. Mexican workers are deemed to be easier to exploit, not just because of the linguistic differences, but more suitable for stoop labor. Guatemalan farm workers have been hired over Mexican farm workers because a lot of them are indigenous and using the 2-year work system on the assumption that they're less likely to denounce unfavorable working conditions. And employers in the same farm separate the workers by nationality and gender. So you'll see, and now in the last part, I just want to quickly move on to this regularization question that Chris raised. So Justicia for Migrant Workers has consistently made this radical demand for status now, and it's a claim against colonialism, racism, and for equality. So media coverage from their Harvesting Freedom campaign led to the Trudeau government to initiate this parliamentary committee, and as part of that, they said, well, let's give them pathways to citizenship. And then in early 2021, the federal government announced this pathway to permanent residence for 30,000 temporary foreign workers. But if you see the language, but if you see what happened, the language requirements, the documentation required, it denied permanent residence to all but a select few of the workers. As of September 2021, only 22 migrant farm worker applicants were deemed eligible for permanent residence, when around 50,000 migrant farm workers were present in Canada, and none were from non-English speaking countries. Another program is the Agri-Food Pilot Program that gives permanent residence for agriculture workers. This year, just for 3 quarters, Agri-Food Pilot PR numbers were at, India had 225 of successful applications, Philippines at 275. So what about the countries from Central America and the Caribbean that form the bulk of these workers? Jamaica were at 5 workers, and Mexico, the largest source country, had 0 workers under the Agri-Food Pilot Program in the first 3 quarters. Another program is the Temporary Foreign Worker to Pathway Residency program. I don't want to talk about the numbers, but Caribbean, Central America, and Africa, in fact, barely scratch the numbers of that program, despite them forming the core of Temporary Foreign Worker program. So this is this formation of a differentialized, differential racialized system. Another discourse you will hear is this enforcement gap. There's just a problem of administration. That Canada has all the rights, but it's just a problem of administration. It's a few large corporatized farmers causing all the problems. But these numbers and the inherent logics behind Canadian food production belies such euphemisms. And my colleagues will go more into it. But racial capitalism functions on the continuous creation of a racialized subaltern and the co-optation of the relatively less exploited, even if they're racialized, because it requires a self-perpetuating chasm between the exploited and the co-opted beneficiaries. I mean, that's just how it works. So you could have continued value extraction and capital accumulation, which is so essential for food production in Canada. These enforcement gaps then are not a chance production by bureaucratic inefficiencies in a federal system, jurisdictional football, and all these other rhetorics that you hear. The legal exceptionalism under which the migrant workers function is deliberately constructed to favor agricultural producers. The conditions facing migrant farm workers are historically produced, and their persistence over decades show purposeful validation of a racialized system of power. And with that, I will stop, and we can move to the next speaker.
Thank you very much. I just want to congratulate the Canadian state. What, 21 people out of 90,000? Hear me clapping. So yes, definitely. So, I think we're, through Shane's presentation, Vasanti's presentation, we're showing that the different so-called efforts of the Canadian state to protect the so-called vulnerable workers are a fallacy or a lie. And this is a system that's set up by design to subjugate workers. Next on the list to talk about the particular unique situation of housing, we'll be hearing from Sarah Khan, who is a graduate of the University of Windsor's Faculty of Law and a lawyer, a day staff lawyer at the Ontario Public Service Employees Union and a member of Justicia for Migrant Workers. Give it up, Sarah. Woo, woo.
Okay, thanks, Chris. So just to, thank you so much, Professor Venkatesh. That was it's so awesome to listen to you as usual. So just to, I'll be talking about housing, the situation with respect to, where migrant farm workers actually live when they do arrive to Canada and work on farms. So I'm going to show some photos, and let's go. Can people see this? Okay, cool. All right, so these are some of the photos that we got from the workers. So as you can see, they don't have much for furniture. Sometimes, there's 12 people crammed in one room. So this is their mattresses. Oh, and the workers also sent their pictures of their food during quarantine. I'm going to stop sharing here. So we spoke to workers about their experiences, with housing, and I'm going to read some excerpts of like the interview that we had with them. Okay, so so one of them described their housing conditions as a prison cell. There are 24 guys in one bunkhouse overall. 12 workers share each bedroom. Workers have no privacy. They don't have any personal space. There's only about 1 meter of space between each bunk bed. Their spaces are overcrowded, and which also often leads to quarrels among workers. After a long day's work, people want to relax, call their family, but there's not a lot of space in these bunkhouses to do that. The kitchen sometimes there's one worker who told us that the kitchen in his bunkhouse had 4 microwaves, 4 refrigerators, 1 stove with 4 burners, and this kitchen was being shared among 24 people. And there was 1 bathroom with 4 showers, 4 sinks, 4 toilets. And they were also having to pay about $25 to $27 out of their paycheck to pay for these utilities that weren't clearly maintained or were hygienic or safe to use. And this worker also mentioned that a Canadian worker would never accept these living conditions. Their rooms do not have a lock or a security code, so anyone can walk into the room. And this worker specifically had an instance where somebody had walked into their bunkhouse and had stolen his cell phone. And in contrast to this, the greenhouses usually have state-of-the-art security. So it's not And as Professor Venkatesh had mentioned, these are corporate farms. These are not the euphemistic dirt farmers who can't afford to pay for a $5 log. Another worker told us that he lives in a house with 21 other workers. They share 4 bathrooms and there's 6 bedrooms. 9 people sleep in 1 bedroom, 2 people sleep in 1 bedroom, and so on. There's no privacy in the house. So the kitchen is also small. It has 1 stove with 4 burners. There's 2 microwaves. The dining room is also too small for everyone to sit and eat. And there's not enough furniture. There's no shelf, there's no closet. There's the bunk beds are also uncomfortable. So imagine, working a 12-hour shift and coming to a bed that's not comfortable, that creaks when you shift. So these are some of the things that we were hearing from workers. During the pandemic, one of our workers told us that the employer did provide cleaning supplies. The employer also gave him a box of disposable masks, and he and his colleagues used those masks, but once those masks ran out, the worker had to go and replace them by themselves. So those amenities or those supplies were not given to them on a regular basis. He also felt that the employer could do more to protect him from COVID-19. For example, people coming into the farm for the first time should all be tested, but the testing was not done on a regular basis. The employer should also provide transportation services in case anyone gets sick or needs essential services, instead of the worker having to do it out of pocket. So these are some of the things we were hearing on the ground. Right. So what is the government doing in order to protect workers? Oftentimes, as you heard from Professor Venkatesh and Shane, that there's usually a jurisdictional football. The federal government is responsible for regulating the bunkhouses. The provincial government is responsible for regulating the work sites. But there's no level of government that's actually taking responsibility for inspecting these housing, ensuring that these conditions are maintained, like that these housing conditions are not decrepit, but that is unfortunately the case. Also with this jurisdictional football, workers are not protected under Occupational Health and Safety Act. Because it's not extended to the housing accommodations that are provided to the workers. And so essentially this creates a division of power, and it creates apartheid because it enables both levels of government not to take responsibility for inspection. Sorry, I'm just looking for my notes here. So Canada's narrative on migrant farm workers is that Canada faces a shortage of labor, and employers use workers from the global south to fill these vacancies. It's clear from the treatment of migrant farm workers that Canadians continue the system of apartheid against racialized bodies through vilification, xenophobia, and dehumanization of migrant farm workers. Apartheid exists by developing legal regimes that deny racialized workers equal protections under the law. Ideological beliefs of migrants as inferior and Canadians as superior are embedded in historical labor practices in the agricultural industry. And our food system is premised on this this social, civic, and political and economic and racial disenfranchisement of migrant farm labor. And this is also a form of environmental racism because racialized workers are treated differently. Canadians would not stand for this kind of treatment. Workers are constantly exposed to toxic chemicals and fertilizers because they're not provided with proper safety equipment. And in the workforce, they're pitted against each other to compete for these jobs because of the immigration system that forces them to be docile, to not assert their rights in the workforce. And these conditions have essentially remained the same since this program was designed in 1966. In fact, some of their rights were taken away through under OSHA, the Occupational Health and Safety Act. And yeah, so these workers are racialized by employers, residents, and the government alike. Yeah, and this is it. I'm going to hand it over to Tanita to talk about the immigration system in Canada, and it's more specifically the open work permit.
Yep, good job, Sarah. Okay,
Why
so
isn't Chris introducing you?
I don't know where Chris went.
I'm right here. I had a
Oh.
whole thing actually. So before Tanita joins, please check out our petition that we just started about a day ago. And also we've got a protest happening for all you people. Shane did a phenomenal job in really kind of naming, shaming the state the other day. And we've got a protest. Let me just make sure, and I could show this properly. No, I don't see it here. I'll come back to that later. Protest this Sunday in Toronto at 1 p.m. at the Solicitor General's office here. And it's around the racial profiling migrant farm workers through a DNA sweep. And we are demanding that the DNA is destroyed. So without further ado, next up is Tanita Doma, who is our staff lawyer at the Migrant Worker Clinic. Tanita enjoys spending 18 hours in the car with myself and my colleagues, listening to really kind of old, decrepit music, laughing at jokes, and she's part of the foundation work of providing the support in the Windsor, Essex areas, and she's done a phenomenal job over the last little while. So give it up to Tanita and keep laughing at all my jokes.
Thank you for that warm introduction. Chris is actually lying. I don't laugh at his jokes. I mostly roll my eyes. We've reached the point where I can do that and he won't be offended. So good afternoon, everyone. I will be speaking about the open work permit for vulnerable workers in the context of solutions to some of the broader issues that have been identified by my fellow esteemed panelists. So for a bit of context, the vulnerable work permit was put into place in 2019, and its intended purpose was to provide a transitional measure for workers who are in an abusive environment. And it's also to assist workers with bridging to a new employer without losing status in Canada. And just as a reminder, migrant farm workers' status in Canada is dependent on them being employed. So if they leave their employer, they effectively lose their status, even if they still have a valid work permit. They can't work anywhere else in Canada because that permit ties them to one employer. So they're in a very precarious situation, always, and especially when they lose their job. It's also incredibly important to recognize that this policy was not put in place out of the goodness of the federal government's heart. It was the product of ongoing advocacy and calls for action from grassroots organizers, including migrant farm workers who continue to work and live under these oppressive conditions. And that being said, this permit is not a final solution. It is, in the government's words, transitional. And I noticed Chris just put up the poster for the Destroy the DNA action. I should have stopped talking. Sorry. Okay. So this permit falls very comfortably into the narrative of a good employer and a bad employer. It assumes that, yes, some farms don't treat their workers well, and here's a permit to facilitate you to a better farm. It doesn't really grapple with the Tide work permit on its own, And the language of open work permit is actually quite misleading because the reality of the permit is that when it ends, and it ends fairly quickly, workers will have to find a new employer-specific work permit. So basically chaining themselves to a new employer once again. And I say it's misleading because workers themselves are understandably surprised and angry when they're told about this reality. They think, understandably, that it's an open permit, so they can work anywhere they are able to. But in reality, they have to go and find a new employer. And so it's not really changing anything for them in the long run. And it's perpetuating the same kinds of problems that put them in the position to need an open work permit in the first place. The permit itself seems to acknowledge the difficulties that a worker would have, but then completely ignores the trauma that's associated with that when workers are expected to find a new employer. And throughout the entire process, workers continue to be kept in a state of temporariness. It almost doesn't matter that the work permit is open because in less than a year, they would go through the process of applying all over again because the permit is not renewable, except they won't have any assistance in that time. They wouldn't have an employer, they wouldn't have any government policy to help them. It's very easy for workers to fall out of status. And we often see the clinic workers coming to us at the end of that 1 year work permit, the open work permit, with nowhere to go because they don't have there's no measure that's been put in place to assist them to keep their status in Canada. And speaking as someone who assists workers with these permits quite frequently, it adds an extra process because even if there's a way for workers to leave the farm, in a few months, they'll be back because their permit is about to run out. So it's not a sustainable strategy, but then it's not designed to be, it's not a renewable permit. The legal standard for this permit is if there are reasonable grounds to believe that a foreign national is at risk or is experiencing abuse in the context of their employment. And IRCC's corporate manuals define abuse and provide examples. But what is not really included as abuse is the differential treatment of racialized workers. Those types of dynamics aren't really included in the manuals, but it's our understanding that these are key features of the program. Pitting racialized groups against each other through preferential treatment is a regular issue we see when speaking with workers regarding this permit. And it's very unlikely that workers will tell us that they've been physically abused by their employer. That's a more obvious or tangible type of abuse. It's much more likely that they'll describe being verbally berated, usually without witnesses, and as a result, without much evidence. And these types of abuse are legitimate as any other form of abuse, but they are very difficult to prove. IRCC provides several examples of evidence that could be used for this application, but the reality is that most of them are inaccessible to workers. It's not reasonable, for example, to expect a worker to seek out the protection of Canada Border Services when workers have told us that Canada Border Services conducts immigration raids at their workplaces. It's similarly not reasonable to expect workers to ask the police for help when, as Shane spoke about before, the Human Rights Tribunal found that the Ontario Provincial Police discriminated against a group of migrant farm workers based on their race and nationality when it conducted the DNA sweep. Although the legal standard is much less than the balance of probabilities, it still relies on the discretion of a visa officer to put themselves in the shoes of a migrant farm worker. And when their case is not as clear-cut as set out in the corporate manuals, it's much more difficult to prove abuse in a way that satisfies officers. The open work permit is also designed to assist a very specific type of worker. This worker has access to the internet. They can read and write in English and French. They have a Canadian phone number. They have a computer. They know how to use Adobe or other PDF creation software. They have access to multiple people to corroborate their evidence. They began documenting their conditions from the moment they started work, and they still have those photos and videos available to them. They can cogently and eloquently explain their situation. They trust authority figures, and they have a community of support, and they have accurate, verified information about the process of applying for an open work permit. That type of worker doesn't really exist. Often workers do require assistance with the permit. And when we consider the situation that workers are in, if they're confined to the farm that they're working at, if their only contact is with other farm workers who are not comfortable speaking about these conditions, especially to the federal government, when their job could be at risk. If workers are always under surveillance by their employers, both at home and work, because they work and live in the same place, it's very difficult for workers to get help. And we know from our work that migrant farm workers are incredibly resourceful and they will find help. But the problem again is why they need to seek out those outside resources. And then the work that should be done by the federal government protecting them in the first place is then downloaded to underfunded and under-resourced community groups and organizations. And even when the work permit is successful, it will likely be issued for a year, even less, as I said. And yes, workers can work anywhere in Canada, but without a new visitor visa, they can't travel home to see their families. We meet workers who haven't been home since before the pandemic because they haven't been able to leave their farm. We've heard from workers that receiving the work permit or even applying for it has been met with threats from their home country or a liaison officer, saying they wouldn't be allowed back on the program if they're complaining about their employer. Other workers have told us that receiving the permit marks them as troublemakers, a label that is continually given to brown and Black workers who raise legitimate concerns about their living and working conditions. It's not necessarily a happy ending for workers who receive this work permit. And in many of these successful applications we've seen, workers come back to us for help for a new work permit or a new visa, or worse, they fall out of status and become even more precarious, as I mentioned before. All of the concerns that I've talked about briefly and that are being raised by other members of the panel are straight from workers' mouths. These are not just our musings. These are from conversations with workers where they're speaking candidly about the conditions that they're facing at great personal risk. Our goal is for workers to be empowered to mobilize together, and we try to facilitate that in all of our work. We assist workers with these types of permits, but during no part of the process is there really an understanding that this is going to fix all of their problems. Although the federal government recognizes that this is not a temporary solution, in the context of their efforts to improve the living and working conditions of migrant farm workers, it's a very weak temporary solution at best. Sorry, they do recognize that it's a temporary solution, and it's a weak one. And it goes to our broader concerns that these types of solutions are not going to solve the many, many issues that come up due to the system of apartheid that is the temporary foreign worker program. No other workers besides migrant workers have their employment tied to their immigration status. Farm workers in particular are the ones who ensure Canada has a food system to speak of. They're the ones working every single day to build the millions of dollars in profits that Canada and employers benefit from. The legal exceptionalism that applies to migrant farm workers extends to their immigration status as well, and could not be more obvious in the way it makes them vulnerable to any and all of the issues that are being raised in this panel. In one of the hard conversations in this conference, the state of work, migrant workers continue to be left unprotected by the government at all levels, while the same governments claim that their policies do protect workers. Our work is aimed, at least in part, in exposing those problems, because the people growing our food deserve much better than this. Thank you.
All right, thank you very much, Tanita. The last person that we've got is Ilya Demesky, who is a lawyer in the Windsor, Essex, Chatham, Kent area. Was called to the bar, I believe, about 2 or 3 years ago, and has got a thriving practice fighting for the rights of workers. Very important caveat, Mr. Demesky does not represent bosses, okay? So if you're a boss and looking to screw over a worker, he ain't the cat for you. So Ilya, all yours.
Thanks, Chris. Appreciate that introduction. And yes, I proudly represent only workers, never the employer. So what I'll be talking about is just reflecting on some of the issues that we've seen during the pandemic and how it has exposed and really fueled the employer's ability to control migrant farm workers through both body and mind. When we were looking at the cases in employment, health and safety, and human rights law, we see a theme of employer practices of exerting power and control on the migrant workforce through 3 means. Number 1, fear. Number 2, legal exemptions prescribed by law. And number 3, othering. I'll start off with the first one, fear. Fear has been used through the pandemic to prevent migrant farm workers from leaving the farm, essentially their residence. It's where they sleep and where they rest. And if they were to leave the residence, they were ostracized. They were seen as defiant ones or treated as troublemakers, sort of to build on Tanita's point. Essentially treating workers as being at risk into a risk. Let me explain that further with the following scenario, which we've seen in a number of workplaces. At the beginning of the COVID-19 pandemic, back in March 2020, some employers instructed their workers to not leave the premises at all, even for food, basic necessities, medication, even exercise. And this was all done in the name of health and safety. The argument being that if one was to leave their residence and interact with others, then they could get sick with the virus and could spread it to their coworkers and their bunkmates. So essentially, you have these migrant workers that were stuck inside, can't leave. And what about getting food? Well, employers said they would purchase the food on behalf of the workers and bring it to them. And there was a grocery list that was provided with food items, and the company was asking for workers to select which food item they wanted to purchase for them. And then they would deduct that food expense from their paycheck. But it became a problem pretty quick, especially for workers who had food restrictions. And the response from the employer was more or less, well, take it or leave it. And some workplaces did have a consent sheet to sign off on that, but what if the worker didn't sign off on it? They still couldn't leave the employer's compound to go and purchase food. And so ultimately, these workers were told, if you leave the premises, the residence, that you'll be disciplined. And you'll even have security guards watching out for you to make sure you don't leave. Not surprisingly, some workers did leave to get the appropriate food in accordance with their needs. For some, this was on the basis of creeds, such as for Rastafarians. Other workers leaving to go to the bank to send money to their family back home. And others simply to see their partners on their day off. And what happened to them? Well, some got disciplined and branded as troublemakers, leading to other workers distancing themselves from these workers, and still others even got fired from their job for simply leaving the residence. And this touches on the other theme I mentioned of othering, when the employer would label a worker who would not comply with their health and safety policy that was essentially confining them to the employer's residence and compound as a troublemaker, and leading other workers to distance themselves and not associate with that worker, which unfortunately for some of these workers, it made them feel isolated and ostracized. At the same time, we've also seen employers in these situations pin workers from one ethnic group against another, and trying to use essentially their ethnic background to label another ethnic background as a troublemaker. From the reports we've seen, this had quite a negative impact on the workers' mental well-being, even leading to some workers resigning. Again, not surprisingly, when you have an employer who confines you to your residence, which in most cases is also provided by the employer, and ultimately using police-like powers to control their freedom of movement. What we saw was practices that segregated workers in the name of safety, turning those being at risk into a risk. The workers were seen as a risk. Workers were branded as a risk that could not be trusted and not allowed to obtain essential needs like food. Meanwhile, keep in mind, other workers who were not migrant farm workers were not branded as a risk. They were allowed to freely move in and out of the workplace and access essential needs like food at grocery stores and go out and interact with family and friends. Those workers were not subjected to being policed and monitored by security guards. Now, as I mentioned, some of the workers did lose their job for violating these company policies, even in instances like seeing somebody outside of the residence, like a close partner. But thankfully, for these cases, it proceeded to the Ministry of Labor. Employment claims were filed and were successful in finding that the worker was wrongfully dismissed. The ministry acknowledged that the company policy was problematic. It was trying to punish the worker for off-duty conduct. But more importantly, the off-duty conduct was simply an activity that individuals had the right to. And that was the main problem here. The ministry criticized employers for punishing workers for simply interacting with someone outside the residence, and that doing so would put other coworkers at risk, impossibly contracting the virus. So potentially getting sick, the ministry found, is not a willful act. The possibility that a worker could have become sick from seeing someone outside of their provided residence is the same risk any person takes in completing day-to-day activities. Now, eventually, these company policies, from what we saw, were scrapped quite quickly, but the impact they made for some of these workers was immense. Losing a job as a migrant farm worker is a lot more severe. It often means losing one's main source of income, their residence, even their ability to remain in Canada, oftentimes being deported after being fired. The second thing we saw was the statutory exemptions under the Employment Standards Act. And they were used to instill a sense of belief that employers cannot be held accountable. You have to keep in mind that a lot of the rights under other industries, other than agriculture in Ontario, they get to enjoy basic minimum rights under the Employment Standards Act, such as the hours of work, eating periods, overtime pay, minimum wage, vacation pay, holiday pay. But none of those apply in farming. In some instances, there is an exception to this exception, but even then, you end up with situations where a worker is fighting for a couple of $1,000s of unpaid wages against a heavily resourced employer. And the system in place also does not make it easy to enforce these very limited rights. For some migrant workers, there are severe language barriers, and unfortunately, the Ontario Labour Relations Board does not provide for interpreters other than French and sign language. So workers have to resort to hiring their own interpreters, which are not always affordable. From a personal experience, a 2-day interpretation service can cost up to $1,000. The other challenge is that the Labor Board may require expert witnesses who specialize in agriculture, and those can cost a few $1,000s, even for 1 day. So when you add this up, the worker may spend more money trying to enforce their very limited rights than what they could actually walk away with if they were successful. And going through these challenges can be quite disheartening and ultimately deterring, despite being a system that is meant to ensure it's accessible and it's one that encourages access to justice. But I do want to end on a positive note. Despite these challenges, workers have found ways to fight back against employer mistreatment through communication between other coworkers and documentation of wrongdoing, essentially exercising powerful agency in a context that does so much to strip them of it. This communication and documentation is then relied upon at a legal proceeding. And even with claims with nominal amounts ranging from a few $100s to a few $1,000s, when you add it all up, you'll see that workers have recovered hundreds of thousands of dollars of money that was rightfully theirs. And it has sent a message to employers that violating their rights, well, you're not going to get away with it. You're going to be held accountable. And that makes this fight worth it, one claim at a time. So I'll leave it there, and if there's any questions, happy to answer.
Thank you very much, Ilya, for your fantastic work, particularly over the this pandemic, and yeah, ensuring that you're going to stick it to the man, literally. So we're going to open up for questions, comments, critiques, reflections. Anybody have anything you'd like to share with us? Questions? You could also do it in the chat box. Yes, Jody?
Hi, everyone. Thank you very much. This was a really interesting panel. I just had a quick question. I was curious, we've talked a lot about the agricultural sector and the migrant experience, and I'm wondering, can anyone be more specific? Do we have statistics that kind of differentiate between types of commodities, types of agricultural sectors that migrant workers are predominantly working in, and how even, the type of kind of farm they're working on has impacted their experiences? Thank you very much.
Anybody want to answer that? No? Well then. So we know that the majority of the farms where workers are working, I can't remember, these are all from data. There's a fact sheet from StatsCan. The data is a little out of date. It came out in 2008. Well, sorry, it's out of Statistics Canada's data from 2018, but it was released, I believe, last year. On farms that have revenues of over $2 million, we see a higher concentration of workers are being employed on those. The largest industries that are employing temporary foreign workers are the greenhouse sector. Then there's the soft fruit. Tobacco still, it's not as big as it was, but tobacco is still a big thing. But predominantly it is the greenhouse industry, which is the largest commodity. But we've got everything from mushrooms to cannabis to worm picking to chicken catching, almost everything under the sun that you're seeing the link. But we could send afterwards what the data from 2018 says and the breakdown of TFWs. But the majority are definitely in larger operations.
Yeah, I appreciate that very much, Chris. And, just knowing where to access this information would be great. So thank you.
Anybody else?
I think Nadia has a question.
Yeah, thank you everyone for a really amazing panel. Really informative, and just all of you were such excellent speakers on hard topics. So thank you so much. So I'm thinking about how Canada uses cheap food narratives to obfuscate, to cover up, to not use the more kind of racialized capitalism lens that all of you have been using in the presentation. And I'm wondering, so the pandemic saw like maybe a moment where people in Canada reflected, for at least the first time I've seen since I've been like in this world, a moment of maybe mild concern for migrant workers in Canada and the experience that they're having. And I'm wondering from you guys, what this kind of thinking of cheap food as a narrative to not talk about racial capitalism, I'm wondering what you see as avenues for kind of collective awareness about these issues, or collective change in this moment of like hyperinflation and rising food costs. And the food system in Canada is really good at dividing people, I think, who should have the similar interests. So I think people who are concerned about food security should care about migrant workers. I think people who are interested in small-scale ecological farming should be really concerned about migrant workers. But the food system and this cheap food narrative and this racial capitalism has a really good way of dividing people who should otherwise, I think, be on the same side. So this is a very protracted question, but I guess I'm wondering, like, in this time of hyper raising food costs, how do we mobilize people to care about migrant workers and to realize that high food costs are endemic of the same problems that lead to marginalization of workers? I don't know if that was coherent, but you guys are all really smart, so you'll say something smart in response.
Can we also get Emily's question too? Emily, I think you've got one as well.
Hi, amazing, wonderful, fantastic, informative presentation. Thank you all so much. And thank you for the work that you're doing. I was curious, I know that the fair bit of the action that sort of the thrust of the activism focuses on sort of like leveraging existing human rights legislation, or pushing back against sorry, my cat is getting into food. Pushing back against things sort of on the individual level, individual rights for the workers. And I'm aware, of course, of the fact that workers cannot organize in Ontario, for example. I'm curious, though, is that an avenue that you folks feel like would also be worth pursuing, trying to change? Trying to make change and trying to give workers the rights to organize, or is that? Yeah, I'm just curious your thoughts on that.
Cool. Any other questions? All right. Who would like to go first? Anybody? So I could call you Visanti. That's okay, right? Right. That's okay.
well, I think Nadia's Chris is really well placed to answer your question, Nadia. I think the main problem is food justice is not needs to be thought about from a global justice perspective. I mean, it's if we think about the rising cost narrative, historically, rising cost narrative have been used, has been direct causes of some terrible famines in the world, including the Ethiopian famine, the Somali conflict, or the decimation of the Haitian agriculture. All of this was used in the narrative of rising food costs, not just in the global north, but also in the global south as part of the whole food trade policy. We need cheap food, even at the expense of the most vulnerable and the marginalized in this. So I think that the narrative of racial capitalism creates this constant marginalization. So you cannot talk about benefits for one group when you're taking, it's like robbing Paul and feeding Peter. It just that is the process of inequality that's been created in just the narrative of food costs. And if you think about food costs, even during the lowest food, the times in which the inflation was the lowest, let's think about how, and Sarah talks about environmental racism in her work, but let's talk about how environmental racism works in food politics, even within Canada. Like, what is the kind of food that is eaten by those who are poor? Why is it that? Why is that not linked to minimum wage across the board? Why is that not linked to sick leave? People were starving during the pandemic. Even as Uber Eats and the gig economy was working overtime to feed the middle class and the upper middle class with food, when there were workers who were not even getting sick leave to feed their families. So this narrative of food cannot be divorced from larger issues of global justice and wages. And and we when we see things like the Ethiopian famine, promptly people like Bono and all these singers go and play music to feed the poor in the global south. But why are the poor in the global south displaced and poor in the first place, right? And our responsibility, the cyclical responsibility, and that's why what Adrian talks about mobilize to immobilize is so interesting, because it's like this cyclical pattern that's been creating in which you're extracting your labor from the backs of the very same people whose food you have robbed in the first place. So it is that there can be no talk about any form of food justice without taking into account these dynamics. That's but anyway, but Chris is the expert on this thing. He teaches 2 courses on this.
No, there's no expert here. I learned from the students. I want to go first to the question about collective bargaining, and I'm sure other people will want to jump off. I just want to give my take. So Emily, I want to be clear. So despite the ideas and the work that may seem individual, irrespective of what the law says, we are organizing outside the law, right? We basically do what they call, I guess, organizing on the margins. So the work that we do, whether it's through the vulnerable work permit or the employment standards cases or the DNA case or anything else that's about organizing, knowing that we don't have legal frameworks to support our work, it takes other forms. So Vasanti talked about the Harvesting Freedom campaign. We've done marches, we're gonna do protests. So it definitely takes different forms, and we try to avoid the idea. And of course, there's always a tension, with the immediate crises versus these long-term goals. But it's looking beyond individual, capacity building to longer systemic transformation, right? On not just here within the state of Canada, but overall. And I think around the collective bargaining piece, there's two aspects that I have to flag. The first is that, and this is going to be debatable within Justicia and within all of us. The current framework, I believe, this is my personal Chris Ramsrud, guy who spends too much time watching YouTube. If we cannot basically look at organizing on one farm, right? The current Wagner model will not work to support or to lead to emancipation. So first and foremost, is just by giving workers collective bargaining rights under the same old model is not going to do anything. And we know this from other examples, such as in Washington, well, not Washington State, more California, where they do have the right to organize, but I believe only about 1% of the workers can. So it's about thinking that, of course, yes, the right to organize, but how do we build sectoral power, right? So how do people on one side have a sectoral, similar to construction and other industries, that covers workers across the field? And just having workers at the current table will not be the road to emancipation. That table has been set up where the workers' voices will be pushed to the side, right? It's about transforming, developing another thing. And this idea, or some people call quackery, of portability or the portability of rights, is for us to start thinking about the right to organize is not just simply here in the nation of Canada, but that same right to organize also manifests in different locations as well too. So collective agreements don't only cover workers here in Canada, but in the home countries as well too. Now, getting to the part where Vasanti talked about, my students, right? They're, and thank God they're not here, so I'm gonna diss them. They're brilliant, right? And, these first year 17 and 18-year-olds, when we're talking about stuff, they're like, sir, like, I'm sorry, but, and this may come off as offensive, but, we should be talking about capitalism, no? I'm like, excuse me, what? You want to talk about capitalism? And I think if we're going to talk about inflation, and the organizing principles that are going to bring the so-called, people call it as consumers, but I call it as part of this democratic, as participants in our food system, the people who are the so-called buying the groceries or getting the groceries, and the workers across the chain, is 3 or 4 principles. One is democracy. Number 2 is naming capitalism and colonialism. 3, about transforming and looking away from corporate food production, and this idea overall about emancipation, right? And I think that these conversations are starting to happen. So if we're going to grasp right now this crisis in food, the opportunities where we start linking to the conditions that workers face, and we start turning it outwards, right? Where we keep pressuring and looking at, that's not simply at corporations, but the entire sway that our system is built upon. I started questioning and asking, why don't people have any space or any decision-making for any aspects of our food system? So this is what I guess I've been trying to think through with my students, right? And trying to think through with workers as well too, right? This idea of democracy, and the Food Chain Workers Alliance, who we're members of, is a critically important space that try to have these conversations to build on this crisis of inflation, to talk about larger goals about food. Who else wants to yap?
Chris, I'll just chime in. I would echo what Chris had to say about needing to, I think, prioritize discussions about capitalism. And by discussions, I mean, even begin with acknowledging its existence, which is something which is so absent in any kind of legal discourse, right? influences every aspect of our lives. It influences how our entire economy works, how we relate to one another in the workplace, how we sustain ourselves as a society. But we act as though it doesn't exist. We act as though it's above even any kind of mention. So I absolutely agree that that's imperative. In terms of working towards unionization for migrant workers, I think that we are also in a time right now where when we look at the two decisions which shut down, well, opened the door and then shut down the possibility for farm workers to unionize, which was Dunmore, followed by Fraser. I think that since the Fraser decision, things have changed quite a bit in the years since. And we see now that the discussion, which was largely, I'll say ignored by the Supreme Court in Fraser, because it's not as though it wasn't present, a discussion about migrant farm workers, because Justice for Migrant Workers, Justicia, did intervene and did try to raise these issues, but they were largely ignored by the court. Things have changed since then, and we have a stronger collection of case law now addressing the issues with migrant farm workers, with the SOP, talking about structural and systemic vulnerability. And I think that will change the analysis if there is another attempt to challenge the relegation of farm workers to the misnamed Agricultural Employees Protection Act, which is the supposed alternative to unionization for farm workers. I think if the case is to be brought again, that focusing in and emphasizing heavily this context of who exactly is doing the work, right? It's migrant farm workers. I think that will influence the analysis that the court applies. But it's a matter of time, I think, just before that case is brought. Not a question of if, but when.
Thank you, sir. Anybody else?
I would like to add.
Go for it.
All right.
Go ahead.
Yeah, so I just want to echo everything that every other panelists have mentioned already. The need to have collective large-scale transformation. And workers are organizing, they have agency. It's just that they can't do it in front of camera. They need to protect themselves as well, because they're supporting a family back home. And there's just practical barriers to organizing, even though in principle they may have freedom of association. There's just issues with the fact that some workers are here half the year, for 8 months, or they're seasonal workers. They have to go back home. But there are organizations back home that are supporting them to an extent, or they might be collectively organizing back home. There's also issues of, that, you don't want your employer to get pissed at you. You want to be sponsored back, right? So you need to show some level of docility, because workers are also getting, surveilled on the farms. They have cameras on the in the greenhouses. The fact that when they leave the property, somebody will know that they're gone. So there's just, practical issues with organizing, and there's rights that we take for granted that they essentially have challenges just asserting because they have to make their employer happy.
Well, thank you. Lucy, you're next.
Yeah, thanks, guys. I just had a question as well, so I wanted to ask, and this is in response to, I think, what Shane was speaking about the human trafficking provisions in the criminal code. And my question is, I'm just curious if you guys think there is a role for the criminal justice system in sort of the justice that's owed to migrant workers. And I think it's recognized that the criminal law and criminal justice is fraught with perils, especially at protecting vulnerable workers, and really achieving sort of institutional justice. But I'm just curious to what you guys think, if there's any role for that. Or alternatively, I suppose, sorry, I'll just add one thing. If, not in the current criminal justice framework, if you do imagine an alternative that could be possible.
I guess maybe I'll just chime in first, and I'll just maybe start by acknowledging one thing, which is I guess language, right? And language can sometimes be a difficult thing for us to work around, especially as lawyers when it's entrenched in things and we kind of are unable to communicate without using particular words. But my colleagues within Justicia have brought to my attention some of the problems with using words such as trafficking, right? And how that those kinds of words can remove worker agency. They can contribute to this kind of Eurocentric savior kind of complex. And they can also, whether directly or implicitly, endorse kind of carceral systems as solutions, right? And I mean, can the criminal code be used to improve the circumstances of migrant farm workers? I would say it's unlikely, and I think that really comes down to a question of priorities and interests, right? And what priorities and interests are informing the criminal law? Well, they're by and large the same priorities and interests that are informing other laws that the state passes, laws that allow programs such as the SOP to operate, right? And I think when we look at whose interests are being prioritized, it simply is not the interests of migrant workers as the most marginalized and dispossessed workers in Canadian society. So I hold no hope that the criminal code is going to provide them with justice in any more of a sense than it provides a lot of people with justice, right? And it's and in that sense, it has failed miserably in many ways by inadequately paying attention to, for example, restorative justice initiatives, and instead, focusing on hyper incarceration or mandatory minimums and things such as this, pandering more to sometimes popular opinion about what supposedly is the best way to address crime without actually looking at the data and figuring out how do we make safer, more inclusive societies. But again, I think this all comes back down to more complicated questions of ideology. What is the underlying ideology behind criminal lawmaking, and also, again, this question of priorities and interests.
Thank you, sir. Anybody would like to add? Oh, sorry, Nadia, bless you. I saw that you were sneezing. Anybody else? What is anything? Yeah, Vasanti.
Yeah, so I mean, just to echo everything that Shane said, especially from a migrant justice perspective, trafficking is a very problematic language to use in general. But the interesting thing, I think this sort of links to Tanita's presentation on the open work permit, is that the United States has a kind of an open work permit, abuse-based open work permit system called the U visa system. So in some ways, it's better than the vulnerable work permit system because the workers, it's like a whistleblower system. So if a worker whistleblowers on an employer, which leads to any form of criminal proceedings, and there are certain labor proceedings, exploitation-based labor proceedings, which also which also are criminal, come under that ambit in the United States. Then the worker gets a minimum 4-year visa with access to permanent residence. So the history is quite interesting. So the history behind that, it was actually framed during the George Bush era, in this narrative that Shane spoke about, this hyper war against crime narrative. We have to do something about trafficking. These workers, the biggest problem the workers have is not racial capitalism or any of these things, but it's the traffickers. That was used. But then the organizations in the United States, some of them mentioned by Chris, they used that. They have used that visa in quite innovative ways. For example, to expand Title IV kind of cases from labor exploitation to bring it under this ambit. To use it, and this whistleblower it was not how they perceived it to be. So they used it to encourage solidarity building, and whistleblowing to have workers. The US is a huge country, so this is only done in places where there's some form of movement in that spaces. But when you think about, I don't know if you all know about the Prestige case, or even the workers being described in Migrant Dreams, the women in both cases, they went through all this and got nothing in return. The Prestige 3 women got a big settlement, but all the other women got nothing for basically coming out and showing all the problems with the system. So in the United States, in contrast, all these women would have got permanent residence in the thing. So it's quite. It's, I think, what the narrative, the laws are going to come in a way, but ultimately it is to do with how we think about solidarity building from these laws, and it's extremely problematic to go down the criminal route. But often it happens, like if we have a conservative government, it's quite likely that the anti-trafficking laws will only become stronger as it did under the Harper era, right? But how we use it. How we use the narrative, I think, is the interesting things to do with it, just as an aside.
Cool, thank you. There's been 3 people who haven't said anything, so I'm going to give them a chance. I see there's Elizabeth Yu, there's a 213 number, and a Banksy, like Banksy, I think. Would any of you 3 like to say anything? Comments, questions? Oh, yeah.
Nope, I'm just listening in. Thanks, though.
Great. The other 2? Just the other thing very quickly about trafficking that I got a flag, and I'm not wearing my tinfoil hat today. That'll be tomorrow. But we've got to be really careful about how migrant organizations and groups that are engaging in organizing get criminalized by the state. So it's very easy under the guise of any of this type of legislation to go after organizing. And that's historically happened beforehand too, right? So that's something we definitely need to flag.
Yeah, even with the Sri Lankan Sansi cases, right? Like for the Tamil, it was the organizations themselves who helped people flee an ethnic conflict, who were at the forefront, who were put in the criminalization, who were criminalized first.
Now, I think if Shane had a choice, be representing migrant workers, fighting against police brutality or organizing against attacks on migrant groups, I think he'd prefer the first, not the latter. Yes, Nadia.
I'm gonna abuse the fact that no one has their hand up to ask another question. I want to build off this question of organizing that you were talking about, Chris. So in recent years, a couple of organizations in the United States have been getting a lot of attention, the kind of worker social driven responsibility, the Immokalee Workers, and now the Milk with Dignity program in Vermont. Do you see that as like in any way a useful thing to think about in the Canadian context? Do we have the same, I'm not even sure if we have the same kind of concentration of production that would allow for that, but I don't know, like, is that even solve the problems to you? Like it's still, workers still have to work into, I don't know, there's still challenges to it. So I'm just curious, like what you guys think about that, because it's getting so much attention in the US and increasingly, like I was at a conference in Hungary this summer and people were talking about it and I was like, how do you know about this random small program in Vermont? But I'm curious what you guys think of that. I know you know about them, so.
Well, first, shout out the Immokalee Workers, the Milk with Dignity campaign, Migrant Justice or Migrant Justice. They do kick-ass work. And there's been a lot of other campaigns that are focusing on the, I guess, a corporate driven model. And I want to be clear, this, the discussion whose TC is going to be contradictory. I think people have different perspectives on this. So, it is an organizing tool, right? And it is claiming victories. I think though there's a couple things that we need to reflect on. This is once again my personal observations. Number one, that a lot of times the campaigns around Milk with Dignity or campaigns like that, not necessarily them, but a lot of them are foundation driven, right? So I think there's a lot of foundational supports that examine and look at try to corporate reform. Number two, it looks at particular kind of leverage points within the system. The third, so far here in Canada, at least for us, it may change with other groups, and other funding mechanisms that will come in the future. We've been looking at the state, right, and trying to attack and confront the state, both provincially and federally, and how they've been screwing over workers through the absence of legislative protections. So that's been one aspect of this too. My personal take is, for instance, whether it's the cannabis industry, who we've had fun with, or the Apple industry or the greenhouse industry, it's about using a particular, confrontation against a particular employer through either direct action or through shaming to address these larger systemic issues. So, some of the farms that we've won cases with, we would go and target them, right? But to talk about these larger systems by design problems. And I think that's what the kind of difference is between us. It's not just simply looking at a corporate campaign, but looking at a systemic campaign. And this is where the naming of apartheid plays, it's a very different, I guess, language that we're talking about. Everybody else, anybody else want to say, contradict, say anything else? Tell me I'm full of shit. Nobody? Okay, Emily again?
Yeah, so I as well, I'm just gonna ask another question. I absolutely love, of course, the transformational change approach. However, if we were to look at SOP itself and like some of the most harmful components and try to chip away at them, so some of the things that jump out to me are the tie to employment, for example, which many of you brought up. If another one, of course, is the government to government relationship of that program is being, it's just so far outside of both of those are so far outside of the bounds of what I think the average Canadian citizen probably even understands, that there are people within their country who are working under those types of conditions and might be there might be opportunity to have the program at least augmented to bring some relief while we're also working on the greater systemic change. So I was curious if I'm on the right track with those things, but also if anybody had other aspects of SOP that they would want to target and remove or augment right away in the short term.
20 years ago, I thought that those were nice short-term goals. 20 years ago, that hasn't happened yet, right? So even if we start thinking that, we have these small incremental and stuff, it does not erase the over 50 years of what we've been seeing, right, of the abuses. So I want you to think about it that more of a long-term perspective here too, that what we consider small incremental doesn't address these foundational issues. And number two, these kind of more reactionary stuff. The industry is asking for the sky, and they keep getting the sky, right? Through this larger expansions, the expansion of commodities. Did you guys have pancakes this morning? Anybody had pancakes with maple syrup? Yeah, maple syrup, all those peeps just got added to the commodity list under the SOP, right? So, they're asking for the sun, the sky, the moon, and the farm next door, and they're getting it, right? So I think we've got to be more bolder and push harder for these other parts of things, right? And that's why this kind of, the open permit, for instance, would not address the issues that we've been seeing. So when a farm worker, for instance, leaves and tries to go to farm B, their effort standing up for their rights, in many instances, workers their names are muddied, right? So they're not going to get a work in another farm, right? We've seen that particularly happen, particularly with women, right? Racialized women. When they try to stand up for their rights, the most offensive things are said amongst employers. So those women, for instance, will not get hired again. Anybody else? All right, having said that, it's 5:55. I think we're good to go. So nobody has anybody last comments? Any final words from the panelists? None?
Thank you so much to everyone. I'll just say that. Thank you for coming and speaking. And I echo everyone else's sentiments that it was really engaging and informative. So thank you.
All right, so sign the petition, come out to the protest. And, if we organize a blockade, join us. All right, so have a great day and peace out.
Thank you.
Take care, everyone.